Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It's Thursday, March 13th, 2025 at 11:03 in the morning. Now we're switching our direction from career technical education now to H342, relating to protecting the personal information of certain public servants. I believe our next presenter is Richard Byrne. Richard, are you with us?
Yes, I am.
Good morning. How are you?
Good morning. I haven't been called senator in a while, but thank you.
Good to see you again.
Good to see you again, too. Thank you. Thank you for the time you spent with me when I was visiting Vermont recently, and thanked all the committee members for the time this morning and for giving some consideration to what I'll have to tell you. My background is I'm a former state legislator. I was a CIO, a governor's appointee to be a CIO for the state of Iowa. I've been a city CIO, university, been a public records administrator, as well as someone who's used public records and been an advocate for the group I'm working for, the Coalition for Sensible Public Records Access, for about 20 years now, to try to keep public records as public as we can, within reason. So again, my name is Richard Varn. I'm their executive director. And I'm going to try to do three things today, with one extra one. I know there's some really good questions asked yesterday about the bill draft, exactly how it would work. And the representative that is to my right in the blue coat, you asked a really good question. I don't remember your name. I'm sorry. I'm going to try to address your question. Yeah, you,
I'm
yeah,
Representative Olson. Hi, good to see you.
yeah, it's good to see you. So I will get to your question that you asked earlier.
Okay, thank you.
Then secondly, I'm gonna go through what I think of as the overall unintended effects of the bill, besides just dealing directly with the bill, and then talk about what I think is a more comprehensive approach to the problem you're trying to solve. So those are the three things I'm going to try to do in my few minutes. So first, I want to just start off with the bill itself and try to address those very specific questions. So on the bill, on page 4, lines 8 through 12, is the definition that was discussed yesterday by the Judiciary Committee chair and others, that said this was a very broad definition, and it is. And it's very broad because if it's within a searchable database at all, it qualifies as being disclosed. Now, all those other things are typical to disclosing, like selling and transferring. But in this case, you've also added the notion that if it is present in a searchable database, of which all databases are searchable, then it is subject to the act to be removed from the database upon a petition. And your question yesterday was, well, why would it, if you go then to the last section of the bill under, well, let me say one more thing first. On page 5, you look at the protected information, which includes not only home address, but almost all of the unique identifiers that an individual would have, related to either their car, their home, or themselves, of the main ones that are used at least. Okay. Then you go to the last section on the exemptions, which you were asking about, saying, well, why is it if under page 8, lines 11 through 15, if someone authorizes the disclosure, well, then can they go ahead and complete their transaction? Well, no, because those bits of information that are going to be used for things like validating someone's identity, for watching out for fraud, for allowing them to get an automobile recall, a safety notice, things like that, those have been removed from the database. So by the time they get around to authorizing, they can't authorize them to go back and recollect all the information, put it back in the database, and then authorize its release. The timing is not right in the way that works. That's not the way those systems work. They collect the data, they hold it until it is requested for a lawful purpose, and then it is used for things like identity verification. So I want to make sure that answers the question you were asking first, because that was a very good one. Is that not what you asked?
I think it's the same. Yeah. I think you're talking about the same topic, so that's great. Thank you.
Okay.
And I probably need to know more about the bill and a little more depth. But I thought the obligation was not to disclose.
Yeah.
And excuse me?
Yeah, that's what I think.
So
Yeah.
let me just piece together my thoughts here.
Yeah.
So if you send a notice, the a data broker is obligated not to disclose.
Right.
Um,
But as I understand it, it has to be removed from the database at that point.
where does it say that it has to be
So it's the
removed?
action that is data broker case cease disclosing or redisclosing. So disclosing by definition is having it in a database that's searchable.
Well,
Not just sending it to someone, it's having it in the database. It's just the way the definitions interact. And if I'm wrong, I stand corrected, but that's the way I read it.
well, I guess my understanding of anyway, the intent, you could craft the language however you want. But my understanding of the intent of the bill was, prohibiting the disclosure after you receive notice, not that you remove it from the database such that if, I think one of the witnesses yesterday talked about, an ordinary real estate transaction of some sort where that information would be necessary. So that, when I looked at subdivision 7 on page 8, I said, oh, that seems to cover that. But you're suggesting that it would be eliminated. And I didn't understand that to be the intent. Maybe it needs to be.
I agree. I don't think it was, but I would also add that then just it would need to be disclosed in the other verbs that are in there in order to accomplish the identity verification. So even if it was allowed to be kept in the database, the authorization of the transaction has to go all the way back to the verification entity that has it, not to the one that they're dealing with. So when you say, I have authorized this to be disclosed, who are you authorizing it to be disclosed from and to whom? It's harder.
It was my understanding that the obligation was on the data broker, not the
maybe someone else.
originator of the original collector of the information.
Now that's who the obligation's on, but that may not be who's invoking the service by the data broker in order to complete a transaction. So you have other parties in the chain of transaction, and it makes it hard to do. I've done these, and I think you've probably done them yourself when you've tried to sign like a document from a bank. They'll actually, for an out of wallet verification, that's really you. So those things, they're dependent. The bank didn't collect the information. The data broker collected the information, and they're using it to verify your identity. Okay.
That's very helpful.
Yeah.
It sounds like a sort of technical issue, but yeah, appreciate it.
But I want to make sure we answered your question. So I'm going to go to the larger issues here. So I want
One second, Richard.
Yeah, sorry.
Nick has a question.
Yeah, I have a very directly related question. So, because I just want to clarify the technical aspect piece. So it does feel, I'm curious if, and maybe this is partially like delete X, confusion as well. The removal piece feels like it is assumed that this could mean that it's deletion versus like technically like marked as private or something, and it feels like that. So I guess I'm curious, like, would it help in the disclosure piece when it is removal to clarify that should not be construed to mean required deletion of data?
That would be a start. I would just say that the general problem is we're dealing with 7 different legal regimes here. There are bills that are on most states that deal with them separately, or that are now overlapping in the discussion this committee's been having. I just want to list those off. I know you're discussing a general privacy law. There are doxing laws. There are Daniels laws. There are data broker regulation and registration laws. There are compliance laws and rules. And then there are a set of effective countermeasures and methods for improving the safety of public employees. All right, I think I've got the 1, 2, 3, 4, 5, that's 6. So those are the 6 regimes we're dealing with. And when you say what works best, well, in a more traditional Daniels law that Sarah O's testified about yesterday, there's a pattern for those that accounts for the things we're talking about, allows for the kinds of exemptions that let the people that are trying to be protected by these kind of bills still transact business and do the normal things that everybody does in life, but their information is not as publicly available through government websites and others and private websites as they are now. So that makes it a little harder to get it. Not impossible by any means, but it makes it slightly harder. So the Daniels Laws bills do that First, doxing laws address what people are doing with the information and whether or not that is an actionable item, either civilly or criminally against them. The general privacy laws, you all are discussing that well in other means there, and those deal with whether or not the information is in fact public or private in the first place, and then what precautions you have to take around it. It helps to have all three of these things being discussed at once before you move to the focus of this bill, which is compliance, and it's selected a single response to compliance, which is a private right of action, rather than other things like compliance, like, for example, salting any lists that are out there in order to determine if, in fact, someone is not following the rules. I think that was asked yesterday about how well do we know if these things are working? Well, one aspect is it working to stop the bad behavior you want? The other one is it working to stop the ultimate goal, which is making public employees safer? So, which kind of leads me to my intro. So if I've answered your question, I don't know if
Yeah,
I did.
great, thank you.
Okay. So I just want to say a little bit about enhancing public safety first, so you know where we're coming from. We've sent 2 papers to you all that deal with this in a lot more depth, both of which have executive summaries, so don't let the 8 and 10 page links scare you. So we think the threats against public employees are growing, and they merit a comprehensive and effective response. We take this threat seriously, and we should match the threat with processes, programs, laws that reduce and prevent risks, deter bad actors, apprehend and punish those who break the law while targeting public employees. Redaction of an employee address is an ineffective response and amounts to security theater, while doing real harm to the many beneficial uses of public records and public oversight in everyday transaction. Existing threat management techniques, which I myself have used extensively in government, provide an excellent methodology for identifying threats and countermeasures worth pursuing to accomplish the goal you've all stated is both yours and the committee you've mentioned and what's stated in the preamble of the bill. Current threat assessments have not fully accounted for new threats and threat targets, extended family members and staff, venues like home and other work location away from the traditional workplace. When we did most of our security work with cyber, and it was buildings, wasn't people. We haven't done the same threat assessments we did after 9/11 about buildings and technology that we now need to do about people because the threats have changed. There are existing laws and models that can provide excellent insights on how to address these threats. Current federal and state laws need to be reviewed and applied to the risk, and new laws may be needed to address emerging issues. We lack any solid evidence that informational obscurity on addresses will deter the determined who have the capacity for violence and harmful behavior. I want to emphasize, we lack the evidence that works. The times demand and public employees deserve a more complete set of policies and programs to enhance public safety for public employees, or safety for public employees, beyond a single, weak, ineffective concept of address redaction, and we need more of a security and depth approach. That's our general take on this. And I just want to highlight what exactly in our paper what do we mean by what is more effective? I went and drew from other people that are dealing with this, states, private industry, the crypto business, federal government, US courts, and I tried to create a list to you of things that they say they're using and they are working. Identity and reputation, credit management, monitoring, repair service. It lets you know. This is like LifeLock, and TransUnion has one of others. That basically, it might be a new benefit you need for all public employees, or at least the targeted ones, so they know when anybody is talking about them or doing anything that relates to them from an informational security perspective. Electronic surveillance, monitoring, and threat detection includes video surveillance, social media monitoring, audio sensors, chemical sensors, AI programs, computer monitoring, and device security. Call screening software and services to avoid harassing and threatening phone calls. They're now free in some cell phone cases. They're good ones that are app-based. Security personnel, when it gets serious, those include routinely assigned locations as well as those that can be deployed when a threat is realized or when the threat level about a person goes up. Physical barriers, cybersecurity training and services, personal safe rooms and panic buttons. Congress has authorized people to do that in their homes with campaign money and other money that Congress has authorized. Self-defense training, self-protection devices and weapons, safety procedures and protections like safe words, pattern variants, having an electronic way to monitor home entrance, not answering the door directly with things like bell cameras, and when a stranger present, and so on. Civil and legal processes and support. Public employees may need assistance to use laws available to protect themselves and pursue those that have harmed or seek to harm them. protective orders, law enforcement and prosecutory personnel, and priorities on prioritizing going after people that are doing this. New criminal and civil laws, I have a whole list of them that the feds have identified, and you need to look at if you have parallels in Vermont. Safe at home programs, which you already have there, your Secretary of State runs, and then allowing government sanctioned identities for those special people that need to be obscured completely, like undercover officers. There's more in the paper we've sent you about how that works. I want to spend just a little bit more time highlighting what I think is happening. So, but I'll answer any questions about that first. Then I'll just finish. I only have 10. I know you don't want to take too long.
Any questions on that piece?
So,
Perfect.
all right, sorry.
So, yeah, I think I get what you're saying. I think you're saying that, this kind of approach hasn't been proven to be effective in reducing harm or mitigating harm to protect the protected individuals, and that there are those other ways to do that. When you talk about those other ways, I could see some agencies, I'm thinking of protective orders, things like that. That might make some sense, but this bill seems to be directed in a sort of targeted way that still leaves a lot of information from that's available now on public agencies available to the public. So I'm wondering if you're thinking about that kind of issue about the public generally likes to be able to see information about their public servants and things like that. How do you balance those two?
And they do, and that balancing act is going on in both lawsuits and in discussions around the country right now, as well as in the Uniform Law Commissioners area. There is a doxing subcommittee that is extensively examining that balancing test between what the First Amendment and other constitutional rights allow and what we can then prevent from being either published or made public about people. Daniel's laws have so far survived tests of being able to allow for obscurity on public websites. And that's what, as Sarah O's mentioned yesterday from CDIA, and what I will tell you today is that a Daniel's law approach, rather than leaping directly into a private right of action as your single method of compliance and having such a broad sweep of how you define this, will be a lot more defensible in court. It will be a lot more administratively friendly to your Secretary of State and other folks that have to administer these laws. And it will be a lot easier to manage it because it will be similar to what the other states are asking data brokers and other data providers to do so that you can make that work. So that balancing test, I think, of saying, if you want to remove it from something that's easily accessed, that's an ineffective, but it is a step that you might say has some possible benefit. It still allows the other transactions to occur, and it also would address some of the constitutional issues that information is still available. But I will tell you that between data breaches and the public availability of this, and I'm from a state that has a lot of small towns like you all are, everybody knows where everybody lives, where I'm from. It's not like this is a secret for most of the places where people are to know where someone is, or it's easy to find out. So it is better to follow those other methods, I will just tell you, because between breaches and common knowledge, where someone lives is a very, very hard fact to protect. Extremely hard. I would say impossible. Been trying to do it with information security on things like identity numbers for most of my career, and it doesn't work. We have 74% of Americans got breached in just one breach. So
yeah, I hear you. I'm just wondering whether some combination of, state agency actions as well as, this is a very targeted type of way to mitigate harm. And, I'm just wondering whether some combination of the two might make, have the most
I agree.
Mitigation effect.
I think a Daniel's law, straightforward Daniel's law, that had just removing it from the public, easily accessible websites and allowed for the exemptions that are necessary, like the Driver's Privacy Protection Act, so that vehicle recalls, automotive supply chain information, vehicle history, so that the person that buys a car down the road can actually get the Carfax and get the vehicle history from Kelley Blue Book or whoever they're getting it from. So Those things can still work if you pass a Daniels laws with the kind of exemptions that are typically put in Daniels laws. And then if you really are serious, and I don't say that sarcastically, I'm just saying I wish I've had death threats myself as a public official. I have many of my friends in my life are public servants. I want them protected. It's passion for me to care about both First Amendment and public records issue and public safety at the same time. I want to see effective solutions, and I've tried to give you a list of things that you can put in any combination with a Daniels law, and those other ones will have a lot more effect. And Daniels law will be something that make people aware, but it's not going to have very much protective effect. I just want you to be aware of that it's that people are going to find out where people live. And a lot of the cases where we're doing legislation by anecdote is they didn't find out from a data broker. They did something else to be able to target a person. We had a case here in Texas recently, and where I'm currently living, they walked in and they shot the judge in their chambers because they walked in and shot them. But not all of these things that are threats against these folks are going to be solved by data brokers where restrictions, why I'm concerned. So I'll just close with maybe just a note here that there are a lot of unintended consequences. The other paper I gave you gives you a list of the kinds of things that are not directly authorized, but eventually benefit either the person or someone else is being protected from that person's actions. I just think there's a lot of cognitive dissonance and inconsistency about what, or broadly American values and regulations from the laws like this are being proposed. Americans want a free society, functioning markets. We want good deals, fair rates for what we get. We want some choices. Americans generally want businesses, especially small and medium ones, that struggle to find customers, provide jobs, remain profitable. We like entrepreneurs that produce new products and services and then challenge entrenched players to help consumers. The Constitution supports free speech and matters about public and commercial interests. Americans widely patronize ad-supported businesses, from broadcast to media to internet and app systems. And it's not easy to square those common beliefs, values, and actions with regulations and laws that say we don't want anybody to know anything about anybody, and then legislating by anecdote. So I'll close there and answer any other questions. I don't want to take too much of your time, but thank you for listening.
Just thinking about the data brokers for a minute, one thing that they mentioned yesterday is the privacy trolls, and this kind of a law. How are your feelings about the effects of, frivolous lawsuits against these data brokers because they're out of compliance, all this kind of stuff? That's similar to, like, of course, we've all heard of the patent trolls, but same sort of situation.
Yeah, I think it is a matter of concern. I always look, when I was policy making and sitting in your chair, I was like, well, what's the effective way to deter, to prevent, to inform, to scare, whatever it would take to basically get the effective answer to do this? And how much does that cost? You're going to end up with a lot of lawsuits that ultimately had nothing to do with public safety for the people you're trying to protect. Say, just take those DPPA, Driver's Privacy Protection Act uses. So if somebody discloses that somebody owns a car and gets a public safety recall notice, I don't think that's what you're trying to prevent here. But that would be a punishable act by a lawsuit under this law. So there are innocent acts, there are incidental acts, and there are things that do not disclose the data to anybody who is a bad actor who's trying to target your public officials at risk. So one, you're not aiming straight, in my opinion. And secondly, you do encourage, as you saw in New Jersey, and if you really want to read something interesting, you should read the motion to dismiss that was filed in the New Jersey case. I'd be happy to send it to the committee address, because it is the most robust review of the First Amendment law and the issues around common law rights to have this information made available to various people that I've read recently. So I will send that to the committee if you're interested. But I just think this balancing test is out of whack when the first thing you do is let everybody sue each other. I think there are many other ways to both pursue the public safety angle and to pursue the compliance angle that are cheaper, that have lower transaction costs, that don't have free riders and unintended extra costs added on to businesses that are not doing bad things that you want to prescribe.
Thanks, Richard. I think, when you're talking about American values, and the Constitution, I think one that was maybe missed that I have been really I guess, celebrating in all of this process is our right to privacy. I think that's what this is fundamentally getting at. I'm just curious. So we have a speaker later who's testifying. So I was kind of reading Lauren Schultz's Private Rights of Action and Privacy Law. And one of the things she states in it is she references a Brim versus Midland credit management case where basically they were saying the threat of punitive damages from a PRA for erroneous reporting under FCRA is the primary factor deterring erroneous reporting by the credit reporting industry. So I'm just curious, like expanding on that in general, like I understand in general industry does not want a PRA in anything, even though it is in a number of different federal laws like FCRA, DPPA, TCPA. And I'm just curious, like, how would you expect us to hold actors accountable if they received a request to have data not disclosed, marked private? I'm not saying deleted because that's not what the intent is. To hold them accountable if they ignore it for a year or anything, or especially if there's escalated harms and threats. So what is our option to hold people accountable for actually taking the action that we're trying to do here?
Well, there are other privacy regimes in and around DPPA and other public records regimes. So I'm going to focus on those for just a second.
Sure.
So many of those have both insurance and audit functionality built into them. Some of those audits are the typical kind you might see when someone checks something to make sure it's working, or you submit the results of that audit. Others are the kind of compliance things like I mentioned, like salting lists to make sure that anything that moves outside, if you don't know what I mean by salting, you're putting in a information into that's either watermarked or otherwise characterized in such a way that when it is used improperly, you know it. So there are other compliance techniques that are aimed at the bad actors that are doing the exact thing you're saying. Now, you spent a lot of time yesterday talking about, like, what are the things you're trying to prescribe against? The ones I've said today are not the ones you're after. You're not after automobile recalls. You're not after getting people good credit and insurance rates. You're not trying to aim at those, but you're hitting them by accident. What you talked about yesterday quite a bit was people finder sites that let people find someone quickly and easily and then go and harass them. That was the main case yesterday. Well, most of the things the data broker industry does or doesn't do is not surrounding the people finder issue. It's usually to enable transactions and activities that are mostly B2B and very rarely B2C, business to consumer. So I would say that your deterrence issue has to be aimed correctly at the folks. You should try other mechanisms for getting compliance first. I mean, if you had you have both contract and civil sanctions for anybody that takes the data and misuses it, that's also a deterrent. And you don't end up with all the costs of the transactions of the lawsuit and the class action cases that drive up the cost of being able to find justice for the person that was harmed and also deter the person that's the bad actor. I just think aiming straighter at those people and finding out who they are through an audit and other mechanism to say who is misbehaving around the things you're saying, who's not taking the record down even though they've been told. I mean, first you'd have to have a decent Daniels Law type mechanism for saying you can't have that and disclose it publicly to people, and you have decent exemptions for the kinds of transactions we talk about. And then you audit to see, are you complying? And then you go after the bad actors, since you'll then be able to target the ones that are the problems. You might even end up with attorney general action against them rather than PRA. That's a thought.
Thanks, Richard. I'm curious just because it came up in judiciary when they were taking testimony. They had an interest in, so as you're saying, like exploring other things like civil. And so your thoughts around criminal, because that came up as an option to explore as well.
Yeah, I think both looking at your current criminal laws for the kind of behaviors that are being described as the real serious problematic ones that scare people and make them not want to be in the job that they're holding or make them fearful for their family and hard to do their work. I think those first need review. Secondly, you need a decent intent section so that you're not criminalizing speech. So I would just tell you that the people managing the doxing committee, Steve Frost from Chicago area is one of the chairs, and they have a battery of First Amendment experts. They're doing a really great job of teasing out what exactly can we do to criminalize any of the behavior that's causing us this kind of heartburn. So I think getting good legal opinions about what you can criminalize and how you'd go about doing it, I think it has to be overt acts that are essentially inciting people to do things against others where the real possibility of harm or damage is imminent. So it's the general standard. So I think if you follow that, you could consider those kinds of things, but I would do them, as I said, in these different separate legal regimes. I would focus on your Daniels Law first. I would consider doxing laws additionally, and I would look at some of the other legal regimes I mentioned in those their own separate category. Then your privacy law, if you end up passing it and the governor signs it this time, then you'll have another layer there if you can get that done.
So one of the comments that was made yesterday was about 150 people all submitting the request at the same time, and the company was not able to respond to that. As part of this, it does say 10 business days, and it makes me think of our open meeting laws, or not open meeting laws, but our public records access in the state of Vermont, which allows for an exception if it cannot be done within 10 days. And that could get rid of that the private right to action. Is that what it's called? Yeah, private right to action, which I'm not a fan of. But putting in a clause in there, how would you feel about that? And I would also like to ask what the impact is on business to business, this legislation.
I'll do them one at a time. So I think the timing is a question. I think it was stated yesterday that some people would like 7,000 days. I don't think anybody wants 7,000 days. I do think what people want, aside from the days, is a reasonable way that the person is identified accurately, that there's an electronic method for sending the data in a secure form to a identified party at the data broker's registered address, location to be told, which would be probably an email or an FTP or another secure transaction mode, to let them know exactly what they're supposed to remove so that you're not getting an unformed request. One of the reasons we have those delays in the public records law is we get a lot of unformed requests asking us for, give me all the records about blank. It's like, well, give me some time, So if you structure the form correctly, you structure the data request correctly, and you do it through an electronic, rational, modern web service that gets pushed to the people asking them to do it, the days will matter less, but you still need a reasonable amount of days. You also can't pancake them up to say, I'm going to send you a whole bunch of them all at once. Some people may need some time to go through and do the database work, to actually go into the database with high-level access permissions and go in and do the work necessary to mark the records in the way that was described by the other representative, to mark them as not to be disclosed in certain cases or certain ways. So that takes some time. You also need time just to get your systems ready to do this. But if you follow a Daniels Law pattern, they've already done this for other states. So you'll have a little easier time of getting it done. The effect of B2B, with the current law, it cuts down a lot of valuable transactions and activities that are frictionless now. And they become more frictionful on quick quotes on car insurance and, just getting, like I said, vehicle history and getting your recalls and loans and other transactions that are not easily all fully authorized by the person by just signing one form and saying, okay, everybody can share their data now. It's hard to do that. So I think it will affect businesses as well as the businesses that are being directly regulated. But that answer your question?
It did, and it makes me want to follow up if you don't mind. So when we talk about that less friction, I'm thinking of instances where there's financial institutions that are trying to find individuals to provide funds. And if that doesn't happen, if they're unable to find them through those searches, it then goes into our unclaimed property, which could cause I don't know what kind of headache that causes on the state side.
No, they have to use their process, which I've met with your state treasurer. You have a good program there for trying to reattach unclaimed property to people. But I think there's a variety of ways that in the background we get interesting opportunities to do things because people know stuff about us. Some of those are annoying as all get out. People calling me to try to get me to renew a car warranty for a car I haven't owned for 2 years is annoying, or sending me letters about it. I haven't owned that car, don't have that car anymore. Some of those are annoying. Some of them are very helpful, like, finding out that, hey, did you know that your property tax payments are out of line with what your neighbors are paying? there are services that do things like that. It's like, oh, I didn't know that, and there are people that help you appeal that, or you can appeal it yourself. So there's these other things that we say, well, we kind of like it sometimes, we kind of don't like it other times. But some of them you throw out the bad with the good. So when you say, like, how does this affect things? It affects a whole bunch of things that we kind of take for granted about advertising, marketing, finding new customers. I work with a lot of startups. I'm going to be meeting next to look at a whole bunch of companies that want to grow their business and education, and especially around the CTE issue you were just talking about earlier. So they need a lot of information to grow their business, just to find people, to know who they should talk to know who to send information to, so they can offer new products and services. So we are two minds on this. We are not absolutist about it, but Americans are of two minds. They want stuff easy, innovative, fast, cheap, great, and they also don't want people to know stuff about it when it hurts them. I get it. Those are hard to do both.
Questions answered.
Perfect.
So you mentioned Daniel's line, and I take it they have been enacted in a number of different states. Is that correct? If we were to take a look at, was more in one state or just one state?
Well, the way I personally preferred to do that, working with either NCSL or having your own service bureau do it, is just basically poll them and do a compare and see where they're differing and where they're not. But I would say that I would look at least 3 or 4. It was mentioned yesterday, Oklahoma and Missouri. I know Michigan is debating it right this year. Am I answering your question? I don't sense I am.
I'll take that as an answer to go look at Missouri's law.
Well, that's one that was mentioned yesterday. I haven't personally read that, but I just look for the pattern to say that, are there exemptions in it? Does it exempt the things that we've been talking about? Does it allow for people to obscure the record from a public website? Does it also consider whether the other thing that was asked about criminal studies says, if someone does something with the intent to harm the other person, are you going to add that in, have an actual malice or other thing about incitement or malice in there? Those are the ones we've seen in Oklahoma and Missouri, and I believe those similar. I don't think they're doing criminal one in Michigan, but they have accommodated many of the other things we've talked about.
Thank you.
Questions for Richard? Okay, Richard, thank you.
Thank you for your time. I appreciate it.
Jeff? Morning.
Hey everyone. Hey everyone. Am I on?
Yes, you
Yeah.
are.
How are we?
Good. Thanks for joining us.
Yeah, thanks for having me here. Let me share my screen if that's okay.
Yep.
I think I have to send a request to be able to do that. There we go. Okay. Give me 1 second here. Sorry, I've got the wrong thing on here. Give me a second.
Not a bad setting.
Yeah, that works too.
Apologies there.
Well, mindfulness coaching for everyone.
Exactly. We can all use a little bit of that, right?
Yeah.
Slideshow. There we go. Now I think I've got it. Okay. And that's not it either. Apologies here, folks. I was off my game for a second here. Okay, share, and I think now I've got it. Okay, you should be able to see my main screen here. Let me get the presenter notes over, and I think we can get this rolling. Okay. There we go. Chairperson, members of the committee, Representative Priestley, thanks for the opportunity to speak today. My name is Jeff Jokish. I'm the CXO of Obscure IQ. My partner Colby Scullion couldn't be here today. He and I specialize in data privacy, digital security, the surveillance economy. Through our work, we track over 8,600 organizations who are engaged in data collection, brokerage, mapping how personal data flows and profits from that, how individuals, especially those in sensitive roles, are put at risk. I didn't put this in my written testimony, but I thought I should give you a little bit of additional sort of detail. About 5 years ago, I started building a database of data brokers. In part, I did that because no database existed. There was the California and Vermont registry. Kudos to Vermont for putting that together, being the first one in the nation to do so. But back in 2012, the FTC put out a report called the Transparency Report on Data Brokers. And they noted in that report that there were probably a lot more data brokers. I think the number was about 4,000 that they suggested might exist. I reached out about 5 years ago to the FTC with the Freedom of Information Act request, asking them to give me a list of data brokers, given that they thought there were so many more. And they essentially told me that they were not tracking data brokers. They had no idea how many there were or who they might be. I also asked the Consumer Financial Protection Bureau for a list, and they sent me a list of about 30 credit bureaus and related organizations. I went to the Privacy Rights Clearinghouse for a list, and they had a few that they published, but there were not a whole lot. There were a few other various organizations that listed data brokers, but really when you added them all together, it amounted to 6 or 7, maybe 800 at that point in time. So I decided to make my own list, and I built that into a database. I now track about 8,600 organizations that are profiling consumers. And I know a lot about each of these organizations, the types of data they collect, the governance issues they have, where they operate, if they're registered or not, who they connect to, if they've been breached, and a whole lot more. My organization, Obscure IQ, helps high-profile clients mostly recover their privacy. We operate in part as an authorized agent, like those mentioned in this law, to help those types of people delete or at least manicure their online presence. The reality today is pretty stark. Personal information has become a weapon. Judges, law enforcement officers, public officials, and others perform critical jobs escalating those threats. Not simply online harassment, but real world dangers from what we've talked about and you've heard for a couple of days now: doxing, swatting, targeted violence. I think that H342 is a necessary response to that growing threat. It addresses the glaring gap in how Vermont protects those who serve the public from unchecked exposure of their personal information. Today, I'd like to sort of focus on the role of data brokers and how that industry fuels those risks. Now, you've heard from Justin Sherman and Debbie Reynolds yesterday about a lot of sort of specifics, and you've heard some response from industry. I'd like to provide you a little bit of a framework and background about how I think you should think about this issue in a more general framework, right? So take a look at this. This is just a little bit about sort of how data flows in general. And this is in the pre-internet era, right? You and the government and businesses and data brokers. In the past here, when we interacted with businesses, the value exchange was very clear. We shared some personal data in return for coupons and discounts and membership and loyalty programs, inclusion in mailing lists, right? Those days are long gone, but most people haven't really fully realized that. And that's really the problem, because the landscape has fundamentally changed. This is the core issue, I believe. Businesses' privacy policies in the data broker industry has really sort of exploited consumers' understanding and their data in ways that were not possible before. In the past, when you shared your data with government and businesses, but data brokers were not really a factor in our lives. Back then, giving your data to one company didn't mean that it would end up in the hands of other businesses or data brokers or even the government. We can't really say the same thing today. So if you look at just sort of one example of how data might flow, this is actually an old example, but I grabbed this slide sort of quickly. What's changed really is that digital data means that data can be copied everywhere really quickly. And so if you consider this example, here a student takes an online survey, in this case sponsored by Advisors, right? Their data gets sent to Experian, a credit bureau for identity resolution and enhancement, and then it goes to ALC, who's now actually Adstra. ALC is sort of a major provider at that point, even though you probably never heard of them. And then they send the information to Ethnic Technologies, who predicts the student's ethnicity and religion and language skills before they repackage it and sell it to a marketer. So you can see one person, a student takes an online course, an online survey, and all of a sudden now 5 different companies and a marketer has their information. This is how data sort of flows through an ecosystem. And this is a very simple little data flow, right? I just want you to sort of understand how easily information can flow through a system and how giving your information to one company means that it goes all over the place. And this is just extremely simple, right? So now let's look back a little bit to even just the early internet, right? When data brokers really entered our lives, it was primarily through ad tech, right? Because ad tech was the internet's funding model. You probably know the story, right? Originally, Google resisted using ad tech to make money, but after taking venture capital, they needed revenue. So the solution was ad tech. They acquired a company called DoubleClick, and that really changed everything because DoubleClick places cookies on your computer, it tracked your browser history, and enabled targeting and personalized ads, which sounded pretty good at the time, right? Everybody wins. You get sort of a free service and, you hopefully get better ads and good value. It seemed really good at the time, right? But it enabled data collection practices that have really gotten out of hand. Here's sort of what it looks like today. The chart's similar, but the landscape is really entirely different. The data broker industry now generates, conservative estimates are $300 billion annually. But it's not just for ads. Now it's for surveillance, right? While some data brokers operate within the law, maybe even most of them, right? A lot of them also sell your data indiscriminately with virtually little oversight. We're going to talk about that in a minute, right? Data flows everywhere. Government agencies may acquire it by bypassing the Fourth Amendment because it flows from you to a business, to a broker, to a government agency, right? With no warrants or anything, they can often just ask for it. But maybe more importantly, bad actors can get it, right? They can either buy it directly from a broker, or they can get it by stealing it, or they can get it because it went to a company or a broker who was breached. And there's so much data flowing, right, that a breach is inevitable. There's so much data out there. One of these companies or brokers is going to get breached every single day, every day, right? So it's inevitable that your personal information is going to be out there. The scale is really staggering, right? So let's take a look a little bit about some historical perspectives here. This sort of tracks technology and a couple different things from back in 1970s. If you look at this red line, you can sort of see the growth of technology over time. It really starts back with sort of mainframes around the 1980s. We got PCs. In the 1990s, we got the web, and then Google just before 2000. Then Facebook and the iPhone and the world of big data and the Internet of Things. And now we have generative AI. Data growth has been even more substantial, even exponential. If you look at this sort of yellow stuff here in the corner, right? The gold cloud here, right? Around 2000, 2005, right? We started seeing, government spying, data breaches, ransomware. It's sort of getting crazy, right? More data collected, more data stored, more data breached. At the top of the chart, you'll see privacy legislation trends. I'm not going to talk about this because that's just it's a whole nother speech, really, right? But the key takeaway is that our current laws do not protect personal data. There's a lot of them, but it's really not actually accomplishing much of anything because we're still just collecting, businesses collecting whatever they want, pretty much. Right? So I want to sort of end here on this slide. Are brokers regulated? And while there are a lot of laws, the answer is really they're not regulated very much. I could go into a lot of detail here. I don't know if I really have a whole lot of time. I think I'm pretty much out of it. I'm actually over time here. We can talk through some of this if you want, but really, there's no comprehensive privacy legislation, right? There's a reseller exemption in the Fair Credit Reporting Act, right? The limitations, there's limitation in coverage of HIPAA and Gramm-Leach-Bliley. There's the COPA legislation for children's, data, but there's an actual knowledge loophole. The Driver's Privacy Protection Act is supposed to keep our driver's license data out of the hands of data brokers, but every DMV sells that data and it goes pretty much directly to data brokers. There's exceptions in most of the state laws, that even the ones that you're talking about. And the gentleman before me was asking for more exceptions. The Supreme Court's not helping much either. I'm going to sort of end there and let you ask whatever questions you might have of me. But I think that we've got a real problem here and we need to protect people. The answer is not more surveillance. The answer is to start to regulate industry.
Thank you, Jeff. Wait.
Thanks, Jeff. Just curious, and I think you started to touch on this, but in your mind, like, does this, I guess, what is the best way to start cleaning up kind of the data broker industry and in general, kind of like big data and, everyone being at risk and being profited off of all the time? It feels like a lot of our big social change has come about because of citizens using things like private right of action in a whole sphere of different sectors. But I'm just curious, like, what is, like, does Daniel's Law, will it help get there? Do we need Delete Act? Do we need comprehensive privacy? Like, or like, what are your thoughts there?
Well, I mean, it's tough, right? I'm not sure any of them are magic bullets. I mean, really, we need privacy as a right, but I don't think we're ever going to get that here in the United States. I think the best we can do is pass laws like these to try to get people to sort of realize they need to take their privacy back. Regulations like the Delete Act and like Daniel's Law, I think, help because we need to formalize how we interact with data brokers. And I don't think that all data brokers are bad. I think the data broker industry in general needs a lot of cleanup. I don't think that all the stuff that they're doing to try to prevent fraud is a problem. But I do think that the fact that the data broker industry exists and that they're collecting all this information and the fact that they get breached on the regular means that they're actually feeding cybercrime as they're trying to actually prevent it. So it's almost an Ouroboros. They're actually creating the problem that they're solving.
Thanks.
Question for Jeff? Jeff, thank you very much.
Thanks. Appreciate your time.
Thank you. Thank you. I think, the committee will come back to this after the floor. We have people to testify. Discussion. So we're on the floor at 1. We have a bill up today and probably have 2 others that are going to be referred to money committees. So Let's be out there to support Herb,
Go ahead.
UCC, he's gonna need it.
I'm sure you're gonna have enough time for testimony after my.
You could discuss that with the speaker. So